I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. I'm here today with my partner, Eduardo Ustaran, to do our annual year in review and predictions episode. For those who don't know Eduardo, he is my co-lead of the Hogan Lovells data privacy and cyber practice. Eduardo is based in the UK with a practice that covers all of the EU and beyond. And I am based here in the United States. So we are going to use this opportunity to do a joint overview and provide our joint experience and expertise to cover the past year's development on both sides of the Atlantic and what we can expect in 2025 and beyond. Eduardo, welcome back to the podcast.
Thank you very much. Great to be here with you at the end of the year.
Well, Eduardo, as you know, this is one of my favorite episodes of the year because it allows us to share a question that we both receive all the time. What is going to happen next? Then that is usually the question of the day. But before we get there, why don't we spend a moment thinking about what we have seen in 2024? What were the big developments and the big trends as we do the year in review? And maybe I want to separate that out into two things, because obviously the biggest question of 2024 has probably centered around AI. And let's get to AI in a moment. Before doing that, however, why don't we cover data protection, privacy, cybersecurity, the kind of the nuts and bolts of our practice that have been in existence for a really long time. So what has happened from your perspective? What are those big key changes over the course of 2024 on non-AI data protection issues in the EU?
Sure, absolutely. Well, I think 2024 has been a year where perhaps enforcement has taken a leading role. And the reason why I say that is that enforcement comes in many shapes and colors. And of course, we like to see, or at least people like to see, the big fines, the big numbers. But when you look at the day-to-day work, what we have seen is a lot of regulatory scrutiny, a lot of regulatory investigations, requests for information, and that has been a real pattern this year. We have also seen, in the context of the European data protection law, the EDPB being as prolific as they always are, but grappling with some of the old chestnuts in a way of data protection law, like lawful grounds and whether you can rely on a payment or subscription instead of consent. And the pay or consent debate has continued on from where it was left at the end of last year. And it has become a real matter of contention, again, to argue what the right lawful grounds are. And of course, I don't think you could have me on a podcast without me mentioning one of my favorite topics, which of course is international data transfers. International data transfers, which are as essential to our lives, to our digital lives as ever. But again, a tightening of the screws through decisions and opinions by the European Data Protection Board, even by the European Data Protection Supervisor that was questioning the use of Microsoft tools by European Union institutions. So overall, a bit of a toughening in the regulators' attitudes and mindsets is how I would summarize 2024.
Eduardo, I'm interested maybe in one core topic, right? Because obviously the EU and the UK are all different countries, all in the EU, different member states, all of whom are enforcing their own, interpreting the GDPR in their own way and with their own implementing statutes, and also trying to emphasize their own priorities and their own perspectives on data protection oriented issues. Are you starting to see more of a consensus in the way that different member states and the UK approach data protection issues? Or are we still continuing to see a fracture amongst those interpretations?
I think you always need to appreciate that the EU plus the UK is a very diverse set of countries, and they all have their cultures and legal traditions. So that will always be the case, and you're always going to have issues that are of greater relevance in some jurisdictions. So, for example, employment-related issues, a big thing in France, possibly in Germany. The use of data for profiling and things like that. So there are countries where this is a real sensitive issue. We've seen Italy being particularly conscious of this kind of things. So you always have the different preferences. You mentioned the UK. The UK, of course, is outside the EU, but we share exactly the same legal framework as the EU in terms of data protection. And at least for now, I'm going to talk a bit about how that may evolve in 2025. But of course, the ICO has always been a little bit different from perhaps the mainstream European regulators. And the ICO, part of the nature of that regulator has been the Britishness in the approach to regulating and the very skillful balance of carrot and stick. And that has continued. And that's a tradition, and the ICO is probably the most prolific in terms of providing guidance out there, trying to be helpful. But it has also been tough, and we have been helping clients with investigations by the ICO, and some of them may have to do with the use of data in the context of AI, and we're going to talk about that. But some of them were on issues like the good old cookies and cookie consent. So we need to understand that in Europe, you do need that multi-country assessment of the law and the regulators' activities to understand what's really going on. But it's a good point. Again, the US is one country, but a country made of 50 states. And what about what's going on and what has happened in 2024 in the US?
Yeah, maybe kind of thinking about that also from the non-AI data protection angle. And I think this 2024 probably met expectations in that we saw several things happen. One, probably to the surprise of nobody, we did not have a federal privacy bill. We didn't have the US version of the GDPR. And as a result, we continued to see the states lead in the development of privacy-oriented legislation. Now, I think we are running up to about 20 or so states, nearly half of the states having a version of a privacy bill, some of which look very similar, some have unique components of them, and all of which, following similar to the same themes, Eduardo, that you just mentioned, are thought of and perhaps interpreted differently by individual people who are in charge of overseeing the implementation of those laws, the enforcement of those laws, and in connection with what the priorities are of those leaders and in those states. We also continue to see a somewhat of a vacuum in leadership with respect to privacy in the absence of that federal legislation. And with the absence of that leadership and with the absence of that universal framework, there are no shortages of regulators and legislatures who are looking to take the lead on such an important area like data protection and privacy. And that is both at the federal level and at the state level. So the number of, privacy or cybersecurity regulators continues to increase year over year. This year, primarily, probably focused in on the SEC around data breach notification statutes and different types of disclosures for publicly traded companies. Areas where we have seen the FTC in particular start to try to develop out more of what its position is on expectations relating to privacy through its general Section 5 consumer protection oriented authority, as opposed to looking at things from a very specific lens. And then we've seen those other areas where, the states, probably led by California, where they see that they are going to effectively act as almost the national or the de facto regulator of data protection, given how large the economy is in California relative to all of the other regions in the world, and given its proximity to big tech. All of that swirl, I think, just continued out in 2024. And, as we'll go into a moment, it's going to be a real disruption in the way that has happened in some key components as we think about what 2025 looks like and the new administration.
A lot to digest there and quite a few question marks for the year ahead, I can see.
Yeah, for sure. So we paused. Wait, we said the big thing, the elephant in the room was AI, which I know, Eduardo, you spend a lot of your days now working on AI oriented issues, digital regulation issues. There's been a lot of developments over the course of 2024, especially on the technology side. And then as the regulations seek to catch up with all of these emerging technologies and new applications of AI, how would you describe those developments over the course of the past year?
Well, I would describe them as pretty frantic because of the pace at which things have happened. But what is interesting is that, of course, a lot of the focus tends to be on new laws, the new regulation, and the AI Act, and we can talk about that. But we mustn't forget that there is existing legislation, very much obviously in the context of privacy and cybersecurity, like the GDPR in Europe. You may have heard of it. And that framework is being applied and very rigorously, I would say, in relation to AI-related uses of data. And something that has been a constant debate this year, literally, and it still is around what I would describe as existential privacy issues around AI and AI development in particular. Perhaps the main one being how do you demonstrate the lawfulness in the use of personal data when building AI models? And perhaps if there is one topic that has been at the very center of that debate has been to what extent the legitimate interest ground can be a sufficiently robust legal basis for the use of data in this context. And of course, anyone who develops AI and obviously is going to be a user of AI will need to understand the significance of this matter. We have seen, I was referring earlier to the continuous regulatory scrutiny and enforcement around many issues. Much of it has focused on AI. And you've seen pretty much every European data protection authority doing something to do with AI and enforcement. And we have seen from the Irish DPC to the Italian Garante, authorities taking a view on what technology companies were doing and requiring even the suspension or at least temporary suspension of the training of AI models using European personal data until they had satisfied these issues like the legal basis or the transparency questions around it. And there was a great emphasis that we saw this year on the use of data protection impact assessments as a tool that was seen as a must-have tool before you undertake any type of data processing involving AI. And even in the UK, we have worked here with clients, companies that were being investigated by the ICO on issues to do with AI and children or the licensing of content, websites that had a lot of content, and to what extent they were able to license that content to third parties to develop in AI. So just on the privacy front, the developments around AI are constant. They still are. They will still be a key area for 2025, but they are, as you can see, a matter of contention for 2024. Do you think in the US, and taking into account that the different states' approaches to this, privacy and AI is also seen by regulators or by attorney generals as a big issue?
100% it's a big issue. The only question is what is it we're going to do about it? And I'd say that it's going to be probably both slow and fast. We'll see some of these first states try to make inroads into developing out a framework. Colorado in this year probably leading the pack of creating something that was much more comprehensive and forward-looking, similar to what you have in the EU with the EU AI Act. That's in some ways an outlier compared to what we see elsewhere. And I think where we see the emerging statutes have been more typical around harms based, issues based kind of areas of regulation. In other words, the United States doesn't usually do well creating legal frameworks for organizations to proactively manage these issues. Typically, the way that we legislate in this country is we find some problem and then we try to figure out a law that's going to solve that particular problem. And so you start seeing laws develop that are going to be focused on transparency, number of, obligations surrounding, hey, if you're interacting with a chatbot, you need to make sure that you're telling people that it's a chatbot. Or if you have an AI, generative AI based communication from a doctor's office, that you tell people that that's based on a generative AI. So lots of transparency issues, lots of issues kind of surrounding discrimination and bias and all of these various things, all really focused in on where is the harm going to occur with the uses of these technologies and how do we legislate around that harm. The other kind of big development, very similar to what we were describing a moment ago on the US data protection side, is because we do not have a leader on AI and we don't have a federal AI statute, we are largely applying existing frameworks, existing areas of legal obligations to this new and emerging technology, which in some ways makes a lot of sense. Typically we don't, every single time a new piece of technology comes out, we don't come up with a whole new suite of versions of laws. We apply existing laws to those. And that's what's happening, except that AI in some ways is so big, so fundamental, it's shaping so many different things that it's creating an area where it's very difficult to discern how is it that organizations can make lawful uses of AI without having to consult every aspect of the volumes and volumes of laws that we have in this country. And that dynamic has played out in a couple of different ways, including that, the Biden administration, issued an executive order telling effectively every federal agency, hey, review how your laws apply to AI. Issue guidance about how you're going to think about AI in connection with existing regulations and existing legal framework. So many, many different perspectives being called in. While at the same time, you see the FTC, the largest consumer protection agency, at least we have at the federal level, kind of trying to lean into what it is that thinks about the lawful use of AI, and state attorney generals starting to also to think about that same issue, including state attorney generals that you wouldn't typically think of as trying to take a forward-thinking approach on this, including ones that are in non-democratic states and Republican states, and so that I think is really where the action has been in 2024 on AI, and may very well continue into 2025, but with a very different focus.
Wow. And that is without taking into account new laws that will emerge or that are coming into effect. I think, of course, on the AI front in Europe, what we have seen is the enormous focus on AI Act compliance, so the EU regulation of AI, which was published last summer and became effective, and is the one thing that I think is important to appreciate, that our audience will want to know, is to what extent the AI Act is going to have the famous Brussels effect, the idea that it's an EU law that becomes a global framework, like a bit the GDPR. And the jury is out really on that. I think there is the issue of the first mover advantage of the AI Act. And indeed, we've seen global companies looking at the AI Act as a point of reference for their own AI regulatory compliance. But of course, the AI Act is such a new law. There is no tradition in a way of complying with that type of regulation, that is going to make it really difficult for that to have the true Brussels effect. And what is happening, of course, is because it becomes effective in different stages with different timelines. Much of the focus right now is on the very first deadline for the applicability of perhaps the most serious aspect of the AI Act, which is the prohibited AI practices. So from the 2nd of February, so literally not even 2 months from now, there will be certain use cases of AI that we see are already out there that would be prohibited in Europe. Uses of AI that can be, for example, around subliminal techniques to try to manipulate, or that could perhaps be perceived as exploiting certain vulnerabilities that people have, or things to do these kind of slightly dangerous things like social scoring, or predictive policing and facial recognition in terms of image scraping. So certain practices that may logically sound quite dangerous, but that are already happening to a certain extent, and they become prohibited at the very beginning of next year. So that's something that companies are probably looking into right now. And then we will see how into 2025, the next deadline, which is in August, in early August, affecting the general purpose AI systems, will be interpreted. And there is a lot right now, a lot of movement going on in Brussels and everywhere in Europe, trying to bring this law up to speed in a way, or bringing themselves up to speed to comply with the law. But that is an interesting proposition. What about your end?
I mean, I think for, as we think about what it looks like for AI in 2025, right? So it sounds like, Eduardo, from your perspective, there are some clear markers around things that must happen, right, under the existing laws that you have developed, and these are things we're going to have some of those same issues where those key areas are going to come into effect in 2025 and 2026. But it's not going to probably have the same type of effect that I think you're talking about, given the comprehensive nature of the statute. And I think even areas where we have some version of comprehensive statutes, there is some movement about whether those draw the right balance between innovation and regulation, which is going to be probably the big issue with respect to AI in the United States. And that balance will add a perspective in the Biden administration that probably move slightly more in the direction of regulation, and thinking about that regulation has to, that innovation has to happen within the confines of specific regulation. I think that's going to change. In the Trump administration, I don't think that the same type of expectation around AI is going to be the same under the way that the Biden administration does. In fact, we are, it's been announced, I think, over the course of just yesterday, and including with a leak in the media, that there will be a new FTC commissioner. The FTC chairman, Andrew Ferguson, who will take over the role of being the chairperson of the majority of conservative appointees on the FTC. And as I mentioned ago, FTC has probably been leading the development of AI precedent and AI-based laws, AI-based kind of expectations, and potentially kind of seeing that as a component of law. And the Commissioner Ferguson has been very direct, including in some of the leaked statements that came across yesterday, that he does not see that the FTC should be the AI regulator. In fact, one of the agenda items that he said was going to reverse Lina Khan, who's the current chairperson of the FTC. He wants to end the FTC's attempt to become an AI regulator. Expressly said that he doesn't want the FTC to step into the position of replacing the fact that there is no federal privacy legislation. That he doesn't want there to be the same focus. We're going to terminate all initiatives investigating so-called AI bias and end the FTC's attempt to pursue cases based on lawful disparate impact discrimination theories. All things that are core and fundamental to the way that AI policy is driven at the federal level. And if this agenda is carried forward, and we have no reason to think that it won't be, at least in the way that the oncoming chairperson is going to think about it, that there will be a very different perspective, and the federal government, in some ways, will pull itself out of the AI-based legislation and AI-based regulation, probably creating more opportunity for the states to lead the way in the same way that they have done for privacy legislation at the state level.
So can I ask you a follow-up question then? Because this is very much linked to the point I was making earlier about this Brussels effect of the AI Act. And if you have a sort of vacuum of federal AI regulation in the US, and I appreciate what you said about the state-specific regulation, but do you think that for global corporations or international businesses that are operating across all the states and possibly many countries around the world, will they be looking to adopt a common AI governance approach and compliance with one particular framework? Or do you think that they will say, okay, well, look, we leave the European Act to the Europeans, it's too difficult for us, well, let's just focus on a few states here and just try to build our AI governance framework around that? What's your sense of what's likely to happen?
I don't get the sense that there is going to be the same level of adoption of a common framework, because I think AI is just creating too many disagreements about how to properly legislate and regulate in this space. It's so big and so difficult. And frankly, many of the legislatures don't understand it, that there's a real fear that creating laws in this particular space will result in anti-innovation and loss of competitive balance, especially against other regions in the world where they're leaning into the development of AI. And that, I think, is going to continue. And so you have not seen, for example, that Colorado's more prospective version of how to regulate AI has really taken off in any other states. A more comprehensive version of what you would see at the state level in California was vetoed by the governor to have that type of approach. And so it's not yet clear that there is the political appetite or, frankly, the drive at the local legislatures for them to create a repeatable law that cuts across multiple jurisdictions in the same way that we've seen in the EU. Sorry, the same way that we've seen on the privacy front. Yeah. That may change, right? That could very well, over time. We don't do things very quickly here in the US, right? We kind of watch things play out, and as the harms start to develop, that's when we start, chasing them. And my guess is that will continue over the course of 2025. Interested, Eduardo, as you're, I know one of the big issues that you often are working on, and I'm interested on hearing you articulate how you're thinking it's going to play out in 2025, is really around the training aspect of AI. I know, areas surrounding, as you were describing, the lawful basis, the scraping activities around creating kind of large data sets that were designed to inform and create these different models, and the privacy implications of that are really difficult. Especially as the data is either pseudonymized or arguably anonymized. How much of that do you expect to be a focus in 2025?
A huge focus. Well, here in Europe, we are eagerly awaiting an early Christmas present that I think has been promised to us to arrive on the 23rd of December. And the present is going to be an opinion. It may be a present that feels a bit like coal rather than a nice fluffy teddy bear. But the Christmas present will be an opinion by the European Data Protection Board on their research and their thinking throughout this year on what should be the appropriate legal basis for the use of personal data in the context of AI training. And they will also probably address other of those existential issues like the rights of the individual and the various principles under the GDPR that apply in this context. My sense is that the regulators in Europe are being pulled in two slightly different directions. And let me elaborate on that. On the one hand, there is this sense that in the original generation of internet privacy issues, the regulators missed the boat, and profiling and behavioral targeting and advertising and all that happened, and the rabbit was out of the hat before the regulators could really tackle those issues. With AI, it's different. They feel they are still required to look at this as things are developing, and this is why I was referring earlier to suspensions of AI training based on these ideas. The regulators want to make sure they get it right. But there is a big but. They are also very conscious that they don't want to be identified as these people who don't realize what's going on in the real world. The real world is embracing AI at all levels. Businesses are embracing AI, consumers are embracing AI. It's all around us. It's like the Christmas song, love is all around us. So AI is all around us. And therefore, regulators they feel they need to appreciate that they cannot really stop what is unstoppable. So they find themselves in that difficult position of they need to try to get it right. They need to make sure that people understand how the law applies, but they don't want to create unrealistic expectations that no one is going to be able to comply with. So it is within those parameters that we will see in 2025 the debate continuing, but trying to provide perhaps some direction, informed, I hope, by pragmatism in terms of how existing laws, the GDPR in particular, need to be interpreted so that if you are deploying AI, or indeed if you are developing AI, you are still able to do that and pursue those objectives, but in compliance with the law. And the key word here is accountability, being responsible for what you do, starting, as I was saying earlier, with a data protection impact assessment and following up with a number of mitigation measures, trying to minimize the ability to identify individuals, for example, or the intrusiveness of any output of AI, or maximizing the accuracy of that output, if we're talking of generative AI, or indeed the new buzzword of agential AI, the idea that we are going to be relying more on AI for all kinds of tasks and all kinds of decisions. And if AI is going to be making decisions on our behalf, then we need to make sure that the right mechanisms, the right measures are in place to ensure that those decisions are the right ones. So an ongoing debate throughout 2025, and possibly one that is underpinned by pragmatism. But that's my hope rather than my knowledge.
I mean, Eduardo, how much of this tension between regulation and innovation is happening with this law and the implementation of this law? Because I think if this type of thing would be proposed here in the US, there would be a reaction by many to say, if we do this, all of this technology is going to be created in Russia, or I'm sorry, Russia, and it's going to be created in China, or it's going to be created outside of this, and then we're effectively just going to be buyers of this technology, and as a result, we're not going to be the ones to create it and have the ability of exporting it. Is that same concern not having the same kind of ramifications in the EU?
Up to a point. I think in the EU, if you are talking of the European Union, I think the cautiousness has won the battle over the fight for innovation. Perhaps some politicians will still argue that innovation should be at the forefront of the policy objectives. But when you look at the AI Act in particular and the direction of travel of the European Commission, the forefront is the protection of safety and well-being and human rights. But the interesting situation we're seeing is in the UK, which of course is no longer part of the EU. And the UK is a bit of a testing ground for this other way of thinking. I can see the dilemma in the UK, like in the US, we had a very consequential election this year. And we have, for the second part of this year, we have had a new government. And the new government is trying to ensure that the country is stable and basically goes forward in a more optimistic way than the way in which the previous government left the country. So the issue here is, how do we achieve this growth that the government has set out to be? The main goal is sustainable economic growth, much of which, for a small country like the UK, obviously has to be based on technological innovation. But of course, it's a government that is more aligned, perhaps, what would have been a democratic presidency in the US, or more on the side of people and more protective of its citizens and so on. And therefore, they want to make sure they get regulation right. I think we will see that sort of a mental dilemma that the government is having in the UK, probably not ending up in the situation in which the EU finds itself, where it's now seen as not sufficiently pragmatic and not sufficiently on the side of innovation. And I think the UK will be leaning more towards the innovation side, and perhaps identifying some very specific risks that they feel they need to address to protect workers or to protect vulnerable citizens, and dealing with those specific risks more sort of sharply, but on the whole, making sure that, a bit like what you were saying in the US, there is an emphasis on innovation and growth.
Yeah, I mean it's a fascinating dynamic. And I mean, I'm interested in your perspective, because I know one of the other things that's happening, even outside of the AI and data protection space, is the whole suite of digital regulation legislation that's going into effect in the EU that covers many aspects of all things data. Any thoughts about where that's headed in 2025?
Well, I can tell you that the main effect that all of that is going to have is very directly on our profession, both as advisors to clients, but also the clients themselves and lawyers advising and working in these areas. Because what I see is that, in the same way, our area of practice that was very focused on privacy and cybersecurity and has been like that for decades is now expanding into the realms of AI regulation and data governance and all of that is goes farther than just privacy and the use of personal data. Suddenly, it's testing us, our ability to focus on all of these issues with the same level of insight and the same level of expertise and knowledge of the law, but in a much wider fashion. And I think that is the issue, that the laws will be passed, the laws will come into effect. We will need to be advising on these laws in a pragmatic way, in a way that can help clients, but we will need to have that wider sense. I mean, what about your perspective? Because the absence of those laws doesn't in the U.S. Doesn't mean that clients and the companies that you are working with don't need to take all those issues into account. And maybe the new administration is going to be very relaxed about some of those issues. But I'm sure that the clients you work with that will not be so relaxed.
Yeah, I think we're just going to see it emphasized differently because we're not going to likely have the same type of overarching legislation, same thing as we just discussed with AI. But in addition to that, there are limitations on how much digital regulation would be appropriate or even lawful in the US, given the overhang of the First Amendment and some of the really, difficult components of how much of what it is that happens online should be thought of as speech and how to protect that speech. But areas surrounding content moderation is a big issue, especially as it relates to kids and online safety, which we've already seen, constitutional challenges to those sets of issues. My guess is we'll start to continue to see areas where that debate is unfolding about how to properly protect vulnerable populations online, in particular children, and how to help them with protecting kind of physical safety and online safety. I think there'll be another component, which I think we've kind of talked about in another different context, is how organizations are embracing technology. And one of the things that I think is becoming a trend, or at least under the current version of the FTC, and may have a less of an emphasis, at least in this upcoming version of the FTC, is that there was very much a focus on how organizations were making responsible uses of technology. What was the process by which organizations decided to embrace new technology? What kind of diligence was being performed? Who was at the table? How is it that those people had the right types of expertise and training to make those decisions? That component, right, which is different in the way that often US laws work, is not only new, but it also kind of maybe gives a way of trying to approach these digital regulation and technology regulation more generally. And my guess is that that will continue to find its way into either guidance, into enforcement actions, which we've already seen, or even in potentially in how some of these AI laws are developed, because really what we're talking about with that is a technology governance practice in the same way that we've been talking about developing AI governance practices. Really, at the core is how do you responsibly use technology, knowing that the technology is going to have many ramifications, from safety to discrimination to privacy to a whole bunch of other components of the way we're doing things, and how can you demonstrate you've done this correctly. Maybe one last prediction, Eduardo, because I know we are running short on time. We can probably do this for multiple hours, but I think probably both of us have a view on what the future looks like for cross-border data transfers. And maybe I'll ask you to go first. Where do you think cross-border data transfer legislation or regulation is going to look like in 2025?
So I think we finish with a critical topic, because international data transfers and global data flows will not be any less necessary next year than it has been in the recent past. But what we're going to face is greater geopolitical uncertainty than ever before, possibly. And I think we can all think of the causes or some of the reasons for this uncertainty, this geopolitical uncertainty in terms of political developments and wars around the world. And sometimes there are wars with the military involved, other times it'll be trade wars. But all of that creates this uneasy situation. Our role, I think, is going to have to involve embracing uncertainty, in the sense that getting used to it and working with, obviously, our clients, trying to make sure that we help them find the ways to mitigate that uncertainty. What that means in practice, for example, is making sure that if we're doing transfer impact assessments, we continue to apply a risk-based analysis of the situation, understanding that the risk is never going to be zero. At a time of political uncertainty, there is not going to be less surveillance. There is going to be more surveillance. But if we need to find ways to make transfers happen, we need to be creative in the way in which we recommend measures for transfers. One of the big developments of the next year in Europe will be the new set of standard contractual clauses for transfers of data from Europe to countries that are outside Europe, but to recipients of data that are subject to the GDPR, even if they are not in Europe. And that will likely be a more pragmatic version of the existing set of standard contractual clauses. So being able to ascertain when to use these clauses, how to introduce them in contractual relationships involving transfers will be really, really important. And I think our role as educators or regulators in this context will continue to be that. Interesting in your perspective, because I know, of course, at the center of all these geopolitical uncertainties is the US. So what's your view on that?
Well, we're going to have a big sea change, and that is going to happen quite quickly. So the United States has long had a general policy that we wouldn't restrict global data transfers. And I think we're seeing some weaknesses on that position, or at least some thawing on that position. In particular, issues surrounding the transfers of data, which the United States government has labeled to countries of concern, namely China, Russia, North Korea, Iran, Cuba. There are kind of a handful of countries that have, resulted in geopolitical conflict. And as a result, the United States is saying, hey, we are going to restrict data transfers, not because we're trying to protect the privacy of individuals in the same way that the GDPR would set out, not in the way that we're trying to make sure that wherever data flows globally, the same types of protections around privacy apply to that data. That's not the focus. Instead, the focus is very much from a national security perspective. How are we preventing access to large amounts of personal data to countries that have adversarial relationships with the United States, such that that information can be used in ways to the detriment of U.S. citizens, whether that be using data to create dossiers on individuals for potential areas where they can, create extortion campaigns, or whether it's trying to take, all of Eduardo Ustaran or Scott Loughlin's data and create AI bots that are designed to predict how Scott Loughlin and Eduardo are going to behave in the future, or not Scott and Eduardo, but maybe a military general or a senior administration official. All of those things are on the table. And so the DOJ in the United States has proposed a set of rules, which we'll do a couple of podcasts on in the next couple of weeks, that are really going to change how global data transfers can work out of the US. And my guess is that because it's national security based, and because the focus primarily is going to have impacts on China, is that the new administration is not really going to change course and may follow some of the ways that the Biden administration has led the charge. It's really, the issues that we have seen in the political debate surrounding TikTok really deployed much more generally to every global organization operating in and out of China. So, Eduardo, really appreciated your perspectives on this. I always love these conversations because I feel like I learn so much, and it's so great to collaborate with you in 2024, and looking forward to a terrific 2025 together as we help clients navigate all of the challenges that we expect, and probably many more challenges that we are not yet on our radar.
All the way, my friend, all the way.
Well, with that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.